from CMAX Kosimampuru to maximum prison at Liukop. There was an order to that effect yesterday.
Yes.
Now, my lord, after consultation with my colleagues, we explained to them the correct procedure to follow if they're dissatisfied with yesterday's court order. And this where we are, my lord.
Yeah, who's the senior gentleman amongst the delegation?
The area commissioner.
It's Mr.?
The area commissioner.
Yeah, fine. Where is he?
Mr. Koza.
Yeah, you can come.
And his delegation.
Yeah, you don't have to get into the box because it's got nothing to do with it. Yep. Your rank is area commissioner.
My rank is deputy commissioner.
Deputy
Commissioner, and my post is the area commissioner of Kosimampuru Resettlement.
You were not here yesterday, no?
I was not here.
It was Mr. Letlake,
Mr. Kabengu.
Tobengulu, and the other gentleman. There were two. Who was the other gentleman, Letlake or Letlake? Leka was not here. Oh, it's just
maybe Matala.
Matala no came. Yeah, let me tell you what happened. You saw today. You just saw today. The court started at what time?
I saw. I witnessed that.
You witnessed it.
Yes, I think as well. I was already in court by that time.
Yeah.
Mr. Letta called me around 10 to 10, saying to me that he needs clarity from me whether he should release offender Ntuli to Lokop or to court. Then I said to him, wait for a moment, that because I'm assigned to come to court to able to see if we cannot able to maintain the status quo. So he had to revert back to the administration process because he already released him to Lokop. Yeah. Which is the wrong process. So I think that might have been the contributing factor.
Yeah, fine.
We apologize for that.
No problem. And yesterday I explicitly stated in court, open court, that I don't have the authority to regulate your area. I don't have it. But my job is to see to it that this case starts on time. You can ask Mr. Baloyi and anybody here. I've never ever been late coming to this court in the 2.5 years. Accused number one will either not be here, 2 or 3 or whatever. Okay? So I was surprised that Mr. Ntuli was not in court. And then the Monday, Mr. Sibiya was not in court on time. I don't know if you know about it.
I'm well aware, my lord, about all those delays. And I had personally intervened in order to unblock the blockages. On Monday, it was about the shackles.
Yeah.
I was called and I said, I'm prepared that we compromise the security for the sake of progress, which I did. I didn't have a problem. So even yesterday, after I heard that the judge has provided the order that he goes to Lokop, I also was willing to make peace with that. But after realizing about the testimony that was provided, which was full of lies, which is not true, from Mr. Ntuli, and the pressure from also my principals, we reverted to the fact that we should be able to come and plead to the judge that we should look at the matter differently, so if possible, because we feel that Mr. Ntuli was afforded the opportunity to present false information to the judge, and also Mr. Kabengu was not in a better position to respond to other questions which were asked to him, which I personally view them as unfair, because Mr. Kabengu was the receiving person after the event of the finding of the cell phone. So obviously for him to appear as if he doesn't know the facts, the person that knows the facts appropriately is Mr. Matlala and his team at Maxima. So, and also we felt that we should able to, we feel this empowered, my lord, that if we put measures, and in my case as the area commissioner, everyone that is giving the whole country a problem is brought to Koshimamburu. We're trying our level best to come up with interventions. And once we receive orders that are disempowering us, we're feeling restless and not empowered. So that is the reason why we thought we should able to come and plead with my lord that we should look at this matter the other way around. And one of the instructions that I got from my principals is that if is not given, we are avoiding to also to delay, because we are aware that the judge yesterday was avoiding that we follow the legal procedure in them applying for that will cause this court to adjourn. Now, for the mere fact that there's an order, we are also forced to apply to appeal that order, which will also cause this court a delay. So that is also what we are concerned, and we are very sensitive about all these things, and we want also to apologize to all these shenanigans that has taken place, and we commit ourselves to making sure that there's a smooth running of this court. And I have taken a personal responsibility as the area commissioner at my level as a deputy commissioner to go down and do my best.
Yeah, no, I appreciate your approach, and I'm a very easy man, very easy. I'm a disciple of Nelson Mandela. He solved intractable issues for this country by just talking like we are doing. I can tell you, in this court, there was a fight here. Do you know about that?
I know about that.
Yeah, I mean, there was a fight. People, and I don't want to talk too much because people think Ngazi too much. But there was a fight here between your staff and the gentleman in front of you. And I intervened also by saying, I don't want to listen to your version and their version because I'm presiding in a criminal case. And I won't make a finding about what you say and what they say, because they will run to the Constitutional Court that that judge is biased. He's already found that my client is wrong, is right. Are you with me? So I just listened and said, it appears there is a problem. And there is a problem. Even today, people came late. Even today, even yesterday, even day before yesterday. It happens every other time. So I actually yesterday preempted people not to understand that I am deciding that A is right or A or B is wrong. I actually made it clear that I don't have authority to make this order. But because this court has inherent jurisdiction, when a judge makes an order today to say the matter will proceed tomorrow, it means it's an order to say at 10 o'clock tomorrow, the matter must start. Although I know our people don't take it like that. They think, it's an order to say tomorrow the case must start at 10. I get surprised. I come here and I drive every day from Meldersrift. I come here, some councils don't come on time. They come with excuses, fine, I understand. But this is the background, and I am only interested that the case should start on time. That's all.
We are well aware of that, Judge. That is why we don't want it also to be contributing to the delays.
And I was very precipitate to say that I mustn't take a man who is classified to go into the juvenile section of the prison and take him to the maximum. I even asked your staff there, maximum and what's Mampuru, do they have the same status? And I was told that is correct. Are you with me?
I'm missing my lot. the
I wanted to know the status of the gentleman. Is he classified in what status? As what?
maximum,
For maximum.
yes.
And then Leukop is at maximum.
We look up, they have a maximum. In Koshimamburu, I have a maximum. That is where he was found with the cell phone.
No,
So-
fine.
Yes.
So that's all I was concerned with, to say I mustn't disrupt your operations. It must also be at maximum. But if you can give me the assurance that he'll be here every time at 9, 9:30 or whatever, 10 o'clock we start, that's all I'm interested in. That's all.
My Lord, I put my head on the block. I will ensure that they are here before 10 o'clock.
I don't have jurisdiction to enter into what happens in your prison. Whether who steals what. It's out of my jurisdiction.
My presence here, my Lord, demonstrates that the matter has been escalated at the high level. So I had abandoned important meetings. I saw them as not a priority. We saw this as a priority, and we are going to see to it that they are here before time.
You want your client to say something?
As the court visits.
And I don't want to hear who is right and who is wrong. Bafunani. All I'm interested in is the court must start on time. The JP, even the Chief Justice, they're on my back because they've never seen a case take so long. Never. I've been 55 years as an attorney and as an acting judge and a judge. This is the first experience I've had. 55 years. I was admitted in 1974. I've acted for about 15 years before I got appointed. I've never seen such a thing. You come to court, you sit, the accused are not here. You come as and when. So I don't know what's happening. All I say, can you guys bring them on time? I'm not fighting anybody.
My
And
Lord,
I'm
we
not
will.
disrespecting anybody. Yesterday I made it clear that I'm not undermining your authority. You may have told.
I had the judge on media as well.
Yeah, I'm not undermining anybody. All I'm interested in, let's start on time. So, don't you make a comment? Ma'am?
Yes, my Lord.
Through your client.
I wanted to respond, my Lord. Thank you, my Lord. My Lord, I agree with His Lordship to say he's not allowed to entertain the issues on both sides, whether this one is correct or whether this one is right. As the court has stated the reasons yesterday of which resulted to the court order, to say for the sake of progress in this matter, the court is going to make the order that is going to ensure that the trial is run and is finalized speedily as it is supposed to be, and the delay is affecting the constitutional rights of the accused to have an expedited trial. My Lord, I submit with due respect that the court order has been granted, and my Lord, it cannot be rescinded.
Who says that? Who says that? You haven't heard of an order being recalled?
Yes, my Lord, I'm
Okay,
making
fine.
my submissions. I've noted the submissions and the undertaking made by the area commissioner, Mr. Khoza, my Lord. However, it is not going to resolve the problem that we're sitting with because there are
I don't
disputes
know about
between.
that. Let me tell you, I'm speaking in open court and I'm talking to the highest authority in the correctional services, and I'm speaking to your client here. I don't want to get into the argument about who stole a piece of bread and what have you. And this order, I can recall it if I'm given the satisfaction and the inclination and the official order that the accused here, they will come on time. That's all. And I even told your client yesterday, even yourself, if he wants to bring an application on urgency to do whatever, to interdict whoever or to stop whatever. That is his constitutional right. All I said is, but it mustn't be brought within the perimeters of the time of this court. This court starts at 10, and it ends at 3:30. You can bring an order outside the perimeters of that time, no problem. Not depriving your client for approaching the court. Okay?
I understand, my
Yeah.
lord. However, my lord, I'm also appealing with this honorable court, my lord, because there is a fight between the two, the department and the inmate, my lord, to say, whilst that has not been resolved, my lord, it is my request before this honorable court that the court order be not recalled in order to afford the accused an opportunity to be able to understand the proceedings, to be able to concentrate throughout the proceedings without being exposed to the situation that is disturbing the criminal proceedings that he is currently attending. It is my respectful submission, my lord, and we are towards the end of the state case, now approaching the defense case wherein we need Mr. Ntoli's full concentration towards his case, my lord. I submit, my lord, that at this stage the interference has got negative impact towards Mr. Ntoli's concentration in attending these criminal proceedings, my lord. That's my respectful submission.
Yes, Mr. Mnisi, what is your view?
As it is the court, my lord, I can only make submissions on what the law says. I think there is something that interprets. You
interpret, no problem.
Yes, ma'am. As I'm saying, my lord, I can only make submission on what the law says. The law says that the court has got, in terms of section 173 of the Constitution, it says the court has got an inherent power to regulate its own processes. Now, the court has made it very clear that for purposes of the smooth running of this trial, the court would invoke its inherent jurisdiction and make an order that specifically for the smooth running of this trial, because there's been some delays, and in fact, I do agree with the court that the number of delays which have happened here are simply for wanton reasons. There's no specific reason that has been stated before court as to a genuine reason why there's been such a delay. Since Monday, the court has almost been starting at 11 o'clock because other accused are not here, but there's no specific reason. We only heard yesterday when this issue was ventilated in court that part of the delays is because these accused person are being treated in a way that they are not supposed to be treated with. So they are basically venting out their frustration by saying, you know what, this is too much. I cannot be expected to go to court and concentrate and at the same time be subjected to such an inhuman and such an undignified way where I am kept here at Koshimampur. Now, the court says, in the interest of the smooth running of this case, and I know that I cannot interfere with the decision of the correctional services as to who must be housed where and who must be housed here. But in the interest of the smooth running of this case, I am going to propose and make an order that Mr. Ntuli then should then be sent back to Leeuwkop, where he says he will be better treated compared to at Koshimampuru. And the court correctly says that I do not want to make a value judgment as to who is wrong and who is right. Now, the court is using its inherent jurisdiction. And the law says, if a person is not happy with the manner in which a court is using its own inherent jurisdiction, Mr. Matlala, you know what the avenues are. It's not like this court decided to thumbsuck the decision and base it on nothing. It is basing it on the Constitution, which says in section 173, the court has got its own inherent jurisdiction to regulate its own processes. What did the court do yesterday was to regulate the process of the smooth running of this case. As you're standing there, Mr. Matlala, Oh, Mbani? Oh, as you standing there, Mr. Koza, you don't have a locus standi to challenge the decision of the court, to challenge the order that the court made yesterday. Because it's an order that comes from the Constitution. The powers that the court exercised yesterday are powers that are conferred on this court by the Constitution. If you are not happy with the decision that the court has made yesterday, you cannot come here in person and say, but we're not happy with the decision of the court, so we therefore want this decision to be changed. You know what process should be followed. You don't have locus standi, locus standi, what do they call it now? Locus standi in iudicio to come and challenge the court decision the manner in which you are doing it now. This is totally irregular. But the operative weight that came from the court yesterday, and everybody else was here, was in the interest of justice and in the smooth running of this case. I am going to order that this should be the case. I am aware that I cannot interfere with the administrative processes of the correctional services, but that from me is derived from what the Constitution is saying. And that is exactly what the law is saying, my Lord. I would still say, my Lord, that what the court did yesterday was in the best interest of the administration of justice. But beyond that, seeing to it that this case, which has been delayed on a number of occasions due to the late arrival of these accused persons, which culminated to the information that the court received yesterday, then the court made an order in terms of the Constitution. If somebody wants to challenge that order that was made in terms of the powers that are granted by the court, by the Constitution, then this is not how that is supposed to be happening. I think Mr. Koza knows better that this is not how things are done. And I personally refuse to go and entertain this very same aspect in the judge's chambers. Because if a person is not happy with the judge's order, they cannot simply say, no, we want to walk into the judge's chambers and go and tell the judge that you are not happy with this decision. That is not how things are done. There's a specific procedure that is followed. If you're not happy with what the court did yesterday in terms of the powers that are conferred on the court by the Constitution, you can either bring a review, you can either bring an appeal. And I can state it for fact that if that were to be the case, I'm going to make an application that I also be regarded as a friend of the court in that regard. Thank you.
Yes, Mr. Msapiri.
As the court pleases, my Lord. My Lord, early this morning we were told that we are requested to come and see the court in chambers because there were officials from DCS that wanted to discuss yesterday's order with the court in chambers. I also joined Mr. Mnisi and said, I am a lawyer for 100 years. I'm not going to see the court in chambers because they've got a legal person that I once met here in court, my Lord. She should know the law. There's a principle in law, my Lord, which is called the functus officio principle. It's a Latin term, my Lord, that means having discharged his duty. Now, yesterday, my Lord discharged his duty. He made a court order. Whether that court order, my Lord, was made incorrectly, correctly, his lordship cannot go back and revisit that court order himself. The court now is functus officio. It cannot revisit its own decision. That decision, my Lord, the legal person from DCS must know, is to make an application to review that decision, make an application to appeal that review, my Lord. But as we sit here, this is an informal discussion that should not affect the court order that was made yesterday, my Lord. My Lord does not have the power to revisit that
order that was made yesterday unless the order is challenged in court or there's a statutory provision that says that order can be recalled, my lord. As the court pleases, those are my brief submissions, my lord.
I have nothing further to add from what my colleagues have submitted before the court. Thank you.
Mr. Choro, will you stand by what you said?
As the court pleases.
So, Mr. Koza, I don't want to call you Koza, I want to call you officially. Superintendent Koza,
No, Commissioner Koza.
Commissioner Koza, sorry. Yeah. You know what, like I told you, I'm a simple man and I'm 78 years. Maybe I'm the oldest in this court. Been around. If people can talk like we are talking, and I told you about Mandela, and find a solution, we don't have to escalate it to wherever, just because of our egos. Are you with me?
I'm with you, my lord.
I've understood your position, and I hope you understand my position.
My lord, I understand very clearly.
Yeah.
This is why I made the commitment.
Fine, and I appreciate it.
I made the commitment before this court.
Yeah, and I appreciate it. You can't live with the status quo as it is. You know, I actually joked that, you know, this gentleman, if he wants to be in Cape Town, I can make an order that he must be housed in Cape Town. Every morning he must be flown to the court so that this case can start on time. That's all I'm interested in. So if you can accommodate him to come here on time, that will be the end of the matter.
My lord,
Because there is a dispute, and I don't want to know about the dispute. There is a dispute. If a person who's being ordered by a judge to come to court refuses to go to court, what should that judge do?
I'm still making a commitment, my lord, that coming to court will not be a problem. I will see to it that it is executed and they will be here before time. And I want also to indicate that inferences are made that there's a fight between the Department of Correctional Services and an inmate on offender. There's no such. The only problem is that we are also trying to help the court that these issues that were raised on Monday and the issues that are raised today should not affect the progress of the court. And we are going to see to it that it is happening like that. And we are well aware. And there is other things that are said by Mr. Munisi. I will not able to go there. I just want us to be given that indulgence. And we are going to do our work. And I'm going to see to it that it is done appropriately and to the best.
But the source of the problem still remains there. And I'm not saying there is a problem. You are categorizing as such. The problem is apparently between two parties.
The problem, my lord.
Whether they are real or not.
No, the problem, my lord, is the lack of discipline of these inmates, which I have a personal responsibility to make sure that we deal with that discipline. Their behavior is the one that is impacting on that. But I have got to put mechanisms in place so that I must make sure that when they start with their shenanigans, the court should not be affected. It must be our own problems.
Okay, fine. I've heard everybody. You know what? I'm going to leave the order as it stands. You can bring an application for rescission. Okay, no problem. But I've heard you and you've heard me. Okay.
I heard, my lord.
Thank you, sir.
Please, the court.
Kade khona ke bafowethu isikhulu salaphayana ke ejele lapha eKhoshemampuru prison uMr Khoza ke kade azile phecelezi nodaba lwayizolo ke lesinqumo senkantolo ke lesinqumo senkantolo esithathile ke zokuthi wena ke mnomzana uNtuli kumele bakuthathe lapha eKhoshemampuru bese bakhambise namuhla bakumikise ngale eLokopo kujela seLokopo ke lapho ke athi yena ke futhi nezinye ke izikhulu asebenzisana nazo khona lapha ke ejele kade behlezi ke futhi lapho ke ngesikhathi kade behlezi bekuxoxisana ngodaba lo bathola ukuthi lento ekhuluma ejele inkosi senkantolo ezolo akulona ke iqiniso kepha kokhuluma amanga kuphela ke lapho ke futhi bese bakhuluma khona njalo lapho ke abameli benu ke nabo basho bathi ngaphansi kozomthetho ke ngaphansi kozomthetho sisekelo wala iningizimu Afrika ke so uthi inkosi enkantolo ke inalo ke ilungelo phecelezi usho ukuthi inalo-ke ilungelo phecelezi nodaba lolu-ke esinqumo esenzile-ke izolo ngaphansi kwezomthetho-ke lapho section 173 kwezomthetho-ke lapho kuwukuthi inkosi yenkantolo-ke kumele ukuthi isebenzise-ke amandla ayo-ke kuthizeni uma ngabe-ke isiboshwa esithize sekhala ngento ethize-ke lapho-ke kwamathi inkosi yenkantolo ingenele futhi ngokujulile bese-ke ithatha isinqumo sokuthi kumele ukuthi umuntu loyo bamikise kulinye-ke ijele noma mhlambe bamthathe bamkhiphe-ke lapho-ke akhala ukuthi akaphathekile kahle khona-ke manje asho inkosi yenkantolo ukuthi ngeke-ke besabuya futhi seshintsha-ke isinqumo sesikhiphile-ke izolo uma ngabe abantu balapha-ke noma izikhulu zalapha-ke ejele zinayo-ke inkinga phecelezi ngodaba lwesinqumo senkantolo-ke kwamele ukuthi baletheke isicelo sabo ngaphambili noma baletheke incwadi ephikisana nesicelo noma nesinqumo senkantolo inkosi yenkantolo esikhiphile-ke elangeni la izolo.
And I can just add, I don't intend to denigrate your status. It's not my intention. I'll never do it. Okay? I can give you a silly example. You see this country. The ANC and the PAC were one organization. The foremost intellectuals in those two organizations, amongst others, was Mandela and Sobukwe. And this is 1960, when they split. The meeting was at the Communal Hall in Orlando. They split on the basis of arguing about whether they must include whites in the ANC or whether they mustn't include whites in the PAC. And both camps realized that these white folks who are our compatriots, they came here in 1652. They're not going anywhere. Since 1960, there were fights, blah, 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 blah. And when Mandela and others in 1990, was it 96 or 94, because he took his oath as the president of this country, they said whites were still in this country. They said whites are still here. In other words, that problem, you can talk around it like this problem. Nobody is being denigrated or his status being, it's not about that, it's about common sense. If you think it is utterly impossible for the Department of Correctional Services to allow accused before court, Mr. Ntuli, to go to Leopold because this country won't function fine. But I don't see it in that light. Okay. Okay.
We understand, my lord.
Yeah.
And we
It's just functionality of reason, that's all.
definitely, and there's nothing that can beat us if we can able to talk. And
That's it, yeah. That's
previously, I made my telephone numbers available to the councils that as the senior manager, should there be problems, I'm amenable to resolve the issues. And even this morning, I confirmed that.
Okay,
So, but my lord, we respect the decision and as the court pleases.
okay,
Thank you.
thanks, Ed. Okay.
Athi umnumzana bafowethu akunalutho-ke angalenza-ke phecelezi nesinqumo senkantolo inkosi yenkantolo sesithathile-ke ezolo futhi basihlonipha-ke isinqumo senkantolo lesinkantolo esithathile-ke ezolo akunalutho-ke abangasenza-ke mayelana noma abangayenza-ke mayelana nodaba lolu lwesinqumo senkantolo.
Okay, thank you. Yeah. Yes, Roy.
As the court please, my lord, just some few procedural issues. Yesterday, we indicated that we intend to update the exhibit list.
Yeah.
We've done that. And yesterday, there was a formal admission, a section 220 admission when Warren of Samunakeri testified.
Yeah, right.
We have incorporated that admission in the list of admission, and we have attached that. We'll just briefly take the court through the, firstly, the list of admissions. That's Exhibit F that has been amended. My lord, we previously indicated that there was a duplication of Exhibit J.
Yeah.
That's the affidavit of Warrant Officer Steenkamp, the facial identification expert. Her report was handed up as Exhibit J.
Yeah,
However, there was a duplication with the statement of Forensic Pathology Officer, Ms. Elizabeth Mukwena. And we did mention to the court previously that we suggest that Exhibit J should remain as it is, referring to the report of Warrant Officer Amanda Steenkamp, the
Yeah.
facial identification expert,
okay,
that since little or
And-
hardly any reference has been made to the statement of the Forensic Pathology Officer Mukwena, that her affidavit should be renamed Exhibit K.
okay,
And we also suggested that paragraph 5 of the admissions which I've just handed up should be amended accordingly and referred to Exhibit K. I did send on the 26th of March 2025 an email to my colleagues drawing their attention to this duplication, and we also mentioned that fact in court. I haven't had any, my colleagues undertook to look into that. I suppose during the course of the day today, they'll just indicate what their standpoint is. Then paragraph 13 of the amended list of exhibit refers to the photo album of Warrant Officer Munakedi, and I'll just quickly read it as it is. The photo album of Warrant Officer T.G. Munakedi, Exhibit ZZZZ in brackets 2, dated 19 June 2025, depicting the aerial photos of South African Police Service Force Lores, depicting the Force Lores Court, depicting the municipal building, depicting the shopping mall next to the municipal building, depicting the Force Lores taxi rank is admitted. The court will recall that yesterday when the witness
yeah,
stepped into the witness box, the all counsel indicated that
Right.
his evidence is formally admitted.
okay,
Thank you. Then, just to come back to the updated list of exhibits, we'll start on page 6. In fact, page 5, I'm sorry. On page 5,
yeah,
paragraph 38, it's exhibit V in bracket 3. It's a new exhibit that was handed up, I think, by Mr. Ramusipili during the cross-examination of Brigadier Gininda. It's the statement of Mr. Tumelo Madlala, dated 5 November 2020.
okay,
And then on page 8, paragraph 76, exhibit, what has been included, exhibit is reference to exhibit DD4 in brackets A. It's a photo of downloads of accused number 2, placed side by side with the identikit, exhibit BB.
okay,
Then paragraph 77, exhibit 4 in brackets B. Those are 18 photos found on the extracts of the downloads of accused number 2's cell phone. Then page 16,
16,
Yes, 16,
okay.
16, paragraph 148. It's Exhibit triple X, there's the affidavit regarding the requests that was made by accused number 1 for certain cars that were involved in his pointings out. That is an affidavit explaining what the situation is, Exhibit triple X. Paragraph 149, Exhibit double Z. Those are extracts of the 2014 diary of Brigadier Gininda.
Okay,
Then paragraph 150, Exhibit double Z in brackets 1. Those are the aerial photographs of Foslores Police Station, Foslores Court, Municipality Building, and surrounding areas taken by warrant of some Nakedi. That is the formal admission that I referred to earlier on.
okay,
Paragraph 151, Exhibit double Z in brackets 2. Those are the inspection in local photos by Sergeant J.G. Mangani. Then paragraph 152, Exhibit double Z in brackets 3. That is the aspect, my lord, that stood down yesterday, and we'll come back to that issue. Paragraph 152.
but the death certificate,
No, the prison records
I see.
regarding the proposition that was made by Advocate Nisi that accused number 1 was arrested in 2013 and released on 17 September 2014.
oh, okay,
Then paragraph 153, it's Exhibit double Z in brackets 4. There was a typing error.
okay.
There's the death certificate of Mr. Tabam Makaleni. My lord, we cannot remember if it has formally been handed up. It was referred to in the evidence, and just out of abundance of caution,
Yeah, it was not handed up.
we just want to,
Is that the gentleman who was at the garage, allegedly?
yes, my lord. The one that's also referred to in
Yeah.
the report of warrant of sustained camp.
Right. Just as a matter of interest, this gentleman, is the inquest over? Was the inquest held? If you don't know, you don't know. Of Makaleng. I see here they say cause of death. They say it's under investigation.
Yes. Well,
Okay.
Sorry, my lord, can I ask for the copy of this certificate that has been handed to the court?
well, we'll find out if
Yeah, fine.
an inquest was held. Then, as far as the real exhibits are concerned, this will be on the last page, page 22.
22.
Yes.
Yeah,
Page
okay.
22. What was handed up,
Yeah.
Exhibit 6. It was a USB containing the downloads of accused number 2's cell phone by a warrant of Sandovu. Then Exhibit 7, and we've realized that there could be, in fact, there's a duplication with Exhibit 10. So Exhibit 7 and Exhibit 10 refers to the same exhibit.
Okay.
This is a USB containing downloads of accused number 3 by Sergeant Mabasa. Then Exhibit 8, it's a USB containing ENC footage depicting Mr. Longwe Twala on the 27th of October 2014 at the house of the Kumalos. Then Exhibit 8A is the series of correspondence that we handed up yesterday and placed on record. It's letters from the Office of the DPP Pretoria, letter from the Office of the National Director of Public Prosecutions, letter from the Director of Public Prosecutions, Johannesburg,
Yeah.
a request from the Senior Prosecutor Boksburg, requesting the Magistrate Boksburg to order for the issuing of a Section 205 subpoena against Mr. John Bailey, the news editor of ENCA.
Oh,
Then yesterday we handed up Exhibit 9, it's a USB containing Section 205 of all the accused except accused number 5, incorporating exhibits DD5D up to G of Ms. Kelly Kumalo Longwe and the RICA information. As we mentioned yesterday, it's basically all the information that Ms. Pinky Fatheligam testified on.
okay.
Then there's a paragraph that should refer to exhibits S. I'm just quickly looking for that paragraph. Yeah, I'm sorry, it's on page 4. Page 4, paragraph 32.
Yes.
Exhibit S, there's the affidavit of Sergeant Moses Mabasa dated 17 August 2020, consisting of annexures A to C. And we mentioned there that annexure S in brackets C is the contact list of accused number 3. Then exhibit S in brackets D, those are photos of extract of downloads of accused number 3, enhanced by Sergeant Mabasa. That's the one depicting what the witnesses described as a gold tooth. And then exhibit S in brackets E, that is a dental report on accused number 3. Accused number 3's dental examination by Dr. Z. Ali at Kalafong Hospital, dated 18 June 2025.
Was that handed up?
Yes, it was handed up. my
Are
lord.
you sure?
Yes, it's exhibit S in brackets E. The court will recall that we even intimated that we wanted to call the dentist, but Dr. Ali, but that Advocate Nisi indicated that he is their witness.
Are you
And-
being
and the-
correct? Oh, okay.
Yes, sorry, I'm sorry, Malo.
No, no, I was saying, is he being correctly quoted, Mr. Mnisi?
Yes, and the court then asked what is the status of exhibit S in brackets E.
Yeah,
Yes, that's where we left it.
that's where we left it. And Mr. Mnisi never pursued it. If I'm wrong, just correct me, because I don't recall it being handed up. I said, is this the correct way of handing up a document where the document is not accompanied by an affidavit?
May I assist, my lord?
Yeah.
It is so that a document was not formally handed in. However, the content of the document in its entirety was read into record by Mr. Mabasa when he was being I think it was re-examination by Advocate Sibanda. He read the entire record of that document, the entire content of that document into record. Thank you.
As long as you are satisfied, I don't want us to get to somewhere and then you say, this judge took into consideration a document which was not proven. If you say, in your view, it's proven, fine.
It was not handed informally as an exhibit, my lord, because I only referred Sergeant Mabasa to specific paragraph
I hear
in that
Yeah,
report.
Fine.
Then Advocate Siwanda took it up and read the entire content of that report into record.
Okay, fine. All right.
As a court, please, my lord, then there's only one aspect that is left. Do we see that it's time for the short adjournment?
That's all.
Can we take the short adjournment at this point?
Okay.
is the weight to be attached to the real exhibit. And that is the issue that will be argued at the end of the case as we demonstrated. So the only hurdle that we had to go over at this stage is to show relevance, and we have shown how this video footage is relevant. As to the weight to be attached there to, it's what will be argued at the end of the case. So what Advocate Nisi submitted, that it should be the evidence should be regarded as pro non scriptura, cannot go up. The video clip, as I said, my lord, qualifies as real evidence. The investigating officer has testified, Brigadier Gidinda. He has identified the person that is depicted thereon as Mr. Longwe Twala. What was now left was the state to show the origin of that video footage, and yesterday, my lord, we were at pains to show a series of correspondence that related to the Section 205 application for the video footage, pursuant to which, my lord, the video footage was then handed up to the state. And the court will recall that from the correspondence, it was clearly stated that the information that is requested is video footage that pertains to the events on the 27th of October 2014 at the house of the Kumalos. And the video footage was then released by ENCA pursuant to that Section 205. My lord, we don't want to present a full-on argument, but even the authorities, the handbooks, and we briefly going to refer to the handbook by the well-known authors Hoffman and Zeffert, South African Law of Evidence, 3rd edition, page 313, who distinguish between documentary evidence and real evidence, and refer to real evidence as consisting of things that can be examined by the court as means of proof. And as we've indicated, my lord, that the footage qualifies as real evidence. The court has examined that during the time when we showed the clip. The learned authors go on to say that the court is entitled to not only look at the article produced as real evidence, but is able to listen to, smell, taste, or feel it. The court is entitled to rely on its own perceptions in observing the produced article. Hence, we're making the submission, my lord, that it does qualify as real evidence. My lord, as far back as 1996, in the case of State versus Mpumlo and others, it's 1986, volume 3, SA 482 is the Eastern Cape Division decision at 487, paragraph C to D. The court held as follows: a videotape, motion picture, or photograph may be authenticated or verified under oath by 1, the photographer or camera operator, B, a person present when evidence was recorded, film or photograph, C, a person qualifies to state that the representation is accurate. We call to the investigating officer who testified that the person shown on the, depicted on the video footage is Ms. Longetwala. And the third requirement is that an expert can also be called to testify about the operation of the equipment. For instance, automatic surveillance camera, who is called to authenticate a videotape, and the court held that the authentication goes to the weight to be attached, not admissibility. And we submit, my lord, that the argument that is being presented now conflates admissibility and weight. Admissibility depends on relevance, which, my lord, we have already argued. There were other cases as well, my lord. The well-known case of State versus Baleka that Mr. Ramusipili referred to. The 1986 volume 4 SA 1005 is the decision of the then Transvaal Provincial Division at 1026B, paragraphs B to C, where the court held as follows, and we quote, "I deal with tape recordings as I would deal with any other type of real evidence. The test is whether it is relevant. It will be relevant if it has probative value. It will only have probative value if it's linked to the issues to be decided." My lord, we've already argued that this proposition has been made, and this video footage deals precisely with that. So we've made the submission, my lord, that it is relevant. It therefore passed muster for relevance. The only issue will then be admissibility that will be, weight. The weight to be attached thereto that will be determined at the at the end of the presentation of the evidence. And the court went on to hold that that the link will often have to be supplied by evidence of identification of voices on the tape, where the identity of the speaker is in issue. As we've already indicated, my lord, the investigating officer has already identified the person on the video clip. What was left was for the state to establish the origin, and that we submit, my lord, through the presentation of the various correspondence yesterday. We showed in our argument how the state happened to be in possession of the video footage. These decisions were confirmed in the other case of Mutata vs. Naya, NO, and another. 2009, Volume 1, SACR 263, and is the decision of the Gauteng Provincial Division. So, my lord, in a nutshell, we are saying the video footage qualifies as real evidence, and all that the state has to prove is relevance. We've already argued, made that distinction between the facts that are used to prove the facts that are in issue, and the facts that we made that distinction, my lord, that the facts that are in dispute and the facts that are used to prove those facts that are in dispute. So the videotape is will qualify as evidence that is used to prove the facts that are in dispute, namely that proposition that was made. As indicated, my lord, even if we didn't have to argue the point now, in light of the submissions of of Advocate Mnisi, we make the submission, my lord, that that evidence cannot be regarded as non-proscriptor, as the court pleases.
But the other thing is the evidence of, is that Bailey, is it before court?
Well, the evidence, no, it's not before court, my lord.
Yeah.
Yes,
Saying he's going to China, he's going to what?
yes, no, that's not before court, my lord, yes.
Yeah, okay. Otherwise, you have closed your case.
Yes, I've closed my case.
And what the law, as I understand it, once you have closed your case, Mr. Mnisi can argue
At the end of it.
at the end of it.
As a court.
Yes, Mr. Mnisi. That's it.
As far as the other issues that you've raised of the cars, the Nishan Qashqai and the affidavit of Mr. Bongani Yende, that we've already addressed. They are also at liberty to subpoena any witnesses to testify in their favor.
Okay.
Thank you, my lord. I'll definitely argue at the end of it all around this video. Another point that I would need clarity on. The state had been indicating in the course of the leading of its evidence that it would not be calling certain witnesses. Those witnesses will be made available to the defense. Now, I want to, actually this is just a re-emphasis that from this point onward, in other words, henceforth, the defense is now in liberty to consult with whoever's name appears in the list of the state witnesses if circumstances were to arise. I just want to confirm if my understanding in that regard is correct, my lord.
As a court, my lord, the law is very clear that any witnesses who is not called by the state is at the disposal of the defense, and that will obtain here. We make all witnesses that haven't been called we make them available to the disposal of the defense, my lord.
Thank you, my lord. I'm going to request just a very short adjournment so that I come with a response on the way forward, my lord. Those were just the preliminary issues that would still have affected the state, but now that they've been ironed out, it's fine. The state is no longer involved henceforth, my lord, except for cross-examining witnesses in an event that they will come to that level, my lord, or to that point.
Hardly half past 1.
So when should I come back?
My lord, if I can...
We can come back at 2.
2 o'clock.
Yes.
Okay, 2 o'clock then.
for, but I think it's a head committee there on the modalities regarding the financing of the application in terms of Section 174, my lord. That's the position where we are now.
Yeah.
We are proposing, because they are saying that the CSC will be sitting on the 6th, and once a decision has been taken, it will immediately be communicated to us. I would therefore request that the matter be adjourned up until the 7th of August, my lord. That is the position now.
Okay.
Thank you.
Yes, Mr. P.
My lord, I do confirm what Advocate Munisi has just placed on record to say that the CMC of the Legal Aid Board will be meeting on the 6th and a decision communicated to us on that day. So the date of the 7th is in order, my lord, as the court pleases.
Yes.
Thank you, my lord. I confirm what has been said by my colleagues. Thank you.
Yes.
Thank you, my lord. I also confirm, my lord, that we are
7th of August.
7th of August, my lord, yes.
Thank you. Yes, Mr. Malui.
As a court, please, my lord, we assume that the 7th of August is a provisional date to decide whether or not to bring the application, if I understand my colleagues correctly.
That is so, my lord.
The provisional date.
Yes. And my apologies for not having communicated the date. Actually, our apologies for not having communicated or suggesting the date of the 7th with the state, my lord.
Okay.
Thank you, my lord. But in any event, that's a provisional date.
As a court, please, my lord, that's in order. We don't have a problem with that.
Bafowethu icaleni ke manje ke yaba ithimba labameli benu liyacela ukuthi icala lihlehliswe ke ngemuva kokuthi kade khona ke inkulumo phakathi kwethimba labameli benu ke futhi novisi lapha kwa legal aid office laba abasebenza phansi kwalo ke ukuthi icala lihlehliswe hlehliswe ilanga lesikhombisa ke ngenyanga kaAugust ekuthizeni khona ke kwisinqumo esoqhamuka ke ngemuva komhlangano ozohlalwa ke lapho ngaphansi kwamahhovisi ase-legal aid bakhuluma khona ke ngodaba lomnotho ke ngaphansi komhlangano wathi yi-CSC ke loyo ke manje sobuya ngelanga lange-7 ngobathi sikhona ke isicelo bangafisa ukuthi basenze isicelo sokuthi saka 174 application sokuthi nidedelwe ke lecaleli noma amacala wonkana labantu basawona sebandedele niyazwa ke bafowethu.
Okay. For those reasons, then the matter is remanded to the 7th of August, provisional date, as argued.
Manje ke yasho ke inkosi enkantolo ukuthi ngemuva kwezathu ke lezi ekhambile bameli benu ke icala libahlehlisa bahlelisela ilanga lesikhombisa ke ngenyanga kaAugust ngehora laka-10 kusasa ke lenkantolo.
Yeah. Thanks, yeah. Okay.
Yeah. Yeah. This gives me more time.